Good morning. It's Friday the 5th, October 5th. Feels like fall out here. It is 54 degrees, but it has this nip to it. Clear sky up above. I love this kind of fall weather. It's got the nip in here. I don't know what the difference is between 54 degrees with a nip and without a nip. There's a difference. I'm actually wearing a thick hoodie. No, it's not a Granite State hoodie. Let's talk about using a narrative to fit facts, to make sense of facts. There's a right way to do it and there's a wrong way to do it. The right way to do it, the narrative answers the questions that you have. The wrong way to do it, it raises more questions. Say, for example, I've seen a screenshot where Fat Parasite says that the reason that I became a lawyer is because my dad lost a case. The case he's referring to is Rietveld v. Rosebud Storage, LLC. The Court of Appeals decision was handed down in 2004. If I became a lawyer because of that case, then why did it take 14 years for me to actually get everything put together? Actually 13 years, because I started putting everything together in 2007. Actually, I started studying for the bar in 2016. 2017, I took the bar and got all the background information and everything and became a lawyer in 2018 after my background check finally went through. Because, yeah, they do crawl up your butt way deeper than Fat Parasite's able to do. Because I actually had to give them references and they did criminal background checks all over the place. I had to give them my fingerprints. I mean, the whole kit and caboodle, whole 9 yards. They called all of my old employers ever since I was 18. Any employer I had since I was 18, and that was a long time ago. That was more than a decade ago. That was almost 3 decades ago. So, long time. Anyway. So, on my bar website, you can see that I graduated from law school in 2000. This Court of Appeals decision, California Court of Appeals decision, was in 2004. Which is entirely the wrong time and place to do anything. I would have had to have decided to become a lawyer prior to applying to law school, because I had decided to become a lawyer. That's why I applied to law school. And that law school started in 1997. So how this particular decision would have any effect on me deciding to become a lawyer is anybody's guess. And in case you're wondering, the actual underlying case, that was in 99 or 2000. So yeah, it takes a long time for the system to churn. And Rietveld v. Rosebud, the reason why you'll see it everywhere is because in California, it's a pretty big decision for lawyers, because it established that they could be sanctioned for failing to meaningfully participate in an arbitration. So there you go. My parents hired a shit attorney, apparently, because he didn't communicate with them and he blew off their arbitration, and then he tried to sue because he got paid to sue. He got paid for his money invested, or his time invested, and not for actually trying to advocate for my parents. So there you go. It didn't actually have any effect on me, by the way, either way, for good or for ill. I had decided to I decided to become an attorney prior to attending law school. I decided I didn't want to be an attorney in my appellate advocacy class, which is, I believe, it was the middle of my second year. I don't remember exactly when it was, but it was appellate advocacy that really turned me off to wanting to be an attorney. That and a lot of the win at any cost behavior of my classmates, which now I realize is basically the way to do it. You are your client's advocate, and yeah, you want them to win. It doesn't matter if they're right or wrong. You want them to win, because that's what you get paid to do, and that's the whole role of the judicial system. It sounds terrible, but I grew up and I figured it out, and that's the way it needs to be in an adversarial system. Both sides have to have an effective counsel swinging for the fences for them. So, but yeah, I had decided not to be an attorney. I want to say it was the middle of my second year, but it was whenever I was in the appellate advocacy class, where you had to actually, they gave you a set of facts, and it was specifically designed. It was a specifically designed set of facts so that there were no cases on point. It was a contested area of the law still. And so you had to come up with an argument as to why your client should win. And they basically split the class up into one half was arguing, as the plaintiff, the other half was arguing as the defendant. And both sides thought 100% sure that their client was right. So you could see why I would be naturally confused and think that it was a terrible situation. Because I like justice. I like fairness. There you go. So I had decided to become an attorney prior to 1997. I had decided to not be an attorney probably somewhere in 99 or 2000. It was before I graduated from law school. I just finished law school because I already had a ton of money sunk into it, and you finish what you start. So the problem with the narrative that I decided to become an attorney after my parents lost a lawsuit is it raises more questions than it answers. And so it's not a good narrative. It's a poor narrative. But Fat Parasite had the fact, and he is desperately willing or desperately seeking to find anything to hurt me rather than just to come clean. And have you noticed how every time he comes up with something, I give you the truth? Every time. Oh, he only sent me, apparently Fat Parasite thinks that I lied because Fat Parasite says he only sent me one private message on Discord. I just show you. I just take a screenshot. There's two. Huh. Isn't it just amazing how easy it is to tell the truth and how unwilling Fat Parasite is to do that? People are speculating that the scars he is showing is a skin reduction surgery after his gastric bypass. And before he found that he just couldn't stay away from the Twinkies, he apparently had a lot of loose skin. And they're claiming that the surgical looking slices look like surgical cuts and not like a girlfriend stabbing him in the arm. So people are still digging into Fat Parasite, and I'm sure they're still digging into me. The difference between us is I don't have a criminal record. I have been thoroughly vetted by the California State Bar. And I'm better at crafting a narrative than you are. Some other interesting things. When someone's claiming that they're the victim of domestic violence, Ben has apparently been involved in a lot of violent relationships, or at least multiple. And that's, once as an incident, twice as a pattern. So you do with that what you will. You can craft your own narrative on that one. It's not really pertinent to anything other than the fact that he's lying and showing a pattern of lying. And each little lie that gets exposed further exposes him for being a liar. Where his trying to bring up irrelevant and stupid facts are irrelevant and stupid. So there you go. Anyway, that's all I really had to talk about today, is crafting your narrative to answer the questions and not raise more. I hope you understand it. It's what lawyers do. We are given a set of facts and we craft a narrative out of those facts that is beneficial to our client. And the other side does the same thing. And the trier of fact will figure out whose narrative is more compelling, whose narrative answers more questions than it asks, and answers those questions more completely. So there you go. Anyway, thanks for watching. I hope you are having a beautiful, beautiful day today in clear skies and crisp fall weather. If you're getting cold, make sure you buy lots of auditor swag, lots of auditor hoodies to keep you warm out there. And remember to bring your DHS memo with you. And always film license plates, because that's how the tyrants get you. Thanks for watching. Have a great day.